Real Washington, a podcast with thought leaders on what's coming next and how ideas become movements. Co-sponsored by the Corporate Council Business Journal, Compro, and the Snyder Center at the University of Maryland Smith School of Business. And now, here are your hosts, Richard Levick, founder and CEO of Levick, and Michael Zeldin, former federal prosecutor and CNN legal analyst.
We are now joined by Harvard Law Professor Emeritus Alan Dershowitz, a scholar of U.S. constitutional and criminal law and a noted civil libertarian. It's said that 15 minutes with Alan Dershowitz can change your case. We are delighted to have him for half an hour. Professor Dershowitz, thank you so much for joining us. I know you just finished a speech and you have a new book out, Defending Israel. Thank you so much and welcome to the show.
Well, thanks. It's a pleasure to be on with you.
Thank you so much. So by even Washington standards, the last couple of weeks have been extraordinary. Do you want to give us a little take on how you see what's happened here?
Well, what I see is some dirty politics on all sides. I think the real question is whether or not anything has reached the level of an impeachable high crime and misdemeanor. I think there's politics going on. The Democrats have to decide whether it's in their best interest to move forward with impeachment. They have the votes if they want it to move forward with impeachment. Will it help or hurt Democrats in swing districts? Those are kind of political issues. And then there's the legal issue. And the legal issue is the one that interests me most, and what constitutes an impeachable offense and whether or not that level has been reached by the conduct alleged here. Those are the interesting questions to me.
And to that point, we know, you and I both, having studied Hamilton and the Federalist Papers, Federalist 65 says this abuse of office, the high crime and misdemeanor, is a violation of the public trust. It doesn't require a violation of a criminal statute per se. And so the allegations that have arisen just yesterday and today of the president using or appearing to use or alleged to have used the powers of his office for personal political gain, that is to obtain dirt on Joe Biden and his son Hunter. How do you analyze that in terms of the abuse of office powers that Hamilton set out?
Well, first of all, I have to disagree with you a little bit on the criteria. Let me do a little bit of background. The big debate at the time that the impeachment provisions of the Constitution were accepted was whether we should be more like the British parliamentary system, or we should really be a republic where the president has very independent powers and isn't subject to a vote of disapproval or a vote of lack of confidence the way they are in the British Parliament or today in the Israeli Knesset, for example. And when a measure was introduced at the framing to include as one of the impeachable offenses maladministration of office, it was rejected on the ground that would give Congress too much power over the president and would turn the Congress into a parliament and the American system into a parliamentary system. And so the framers decided instead to have very specific criteria for impeachment, treason, bribery, or other high crimes and misdemeanors. The way I understand Hamilton, and I know other scholars disagree with me, remember the words high crimes and misdemeanors is written in the conjunctive, not the disjunctive. It's not high crimes or misdemeanors. It's high crimes and misdemeanors. The way I interpret it is you need both crime, and the crime has to be one that shows an abuse of office. And my best evidence for that grows out of Alexander Hamilton's own life. He was charged while he was Secretary of the Treasury with a very serious crime. We might think it wasn't so serious today, but he was accused of adultery and of paying extortion money. And he was guilty of those crimes. He admitted it in an essay that he wrote. But he was also accused of using Treasury funds to pay the extortion. And he not only disagreed with that, he wrote this essay embarrassing his wife, embarrassing his family, admitting the adultery and the extortion, and proving that he didn't pay out of Treasury funds because he knew that payment out of Treasury funds would be an abuse of office. It would also be a crime. So for me, the way I interpret the Constitution, and again, I may be a dissenter on this, I think you need both a criminal act, and the criminal act has to be a high criminal act that is an abuse of office. Bill Clinton committed a low crime perjury about his private life. And if, in fact, President Trump had committed a crime in his conversations with the president of the Ukraine, that would probably be a high crime because it would be an abuse of office. But what you have to find first, I think, is a crime. Now, you make an interesting point when you say criminal statute. There weren't very many criminal statutes at the time of the framing. There was a lot of common law. And in 15, the United States Supreme Court for the first time ruled that it would be unconstitutional to have a federal common law of crimes, that you needed to have statutes. And so the statute books are now filled with criminal conduct. So I'm not sure it has to be a crime in the most technical statutory sense, but it has to be criminal in nature. It can't just be abuse of office, maladministration of office. It can't even be corruption, colloquially speaking. It has to be criminal conduct of a criminal nature. And I just can't find that in these conversations. I think there are good reasons in these conversations not to vote for the person who had those conversations. And that's the ultimate check on the president, elections every 4 years.
Do you find yourself moving? 3 years ago, you wrote the book, and I know it was originally the case against impeachment for Hillary Clinton, and then that changed right to Donald Trump. And you've talked in other speeches about the importance of principle and the either shoe approach, which we should get into. But do you find yourself moving? I know these are very fast-moving events, but as more and more information is coming out, do you see yourself pulling away perhaps a little bit from the very articulate defenses you've given over the last few years?
Well, first, I don't want to be seen as somebody who's defending Donald Trump. I didn't vote for him. He is the president of the United States. I'm defending the principles of the Constitution, and I'm defending the principles against weaponizing both our criminal justice system and the Constitution. So I'm going to call them as I see them. If the evidence were to avail itself and become public, moving more toward an impeachable offense, I will say that. My goal is not to protect or defend any particular person, whether it be Hillary Clinton or Donald Trump. It's to make sure that we don't expand what an impeachable offense means or what a crime means. We live in a world where we're constantly expanding our criminal law, using terms like fraud or obstruction of justice, which are elastic terms and which can be used selectively in a political manner. And I'm very much opposed to that. And that's why I always talk about the shoe on the other foot test. The first question I ask myself is, what would I be saying if Hillary Clinton had been elected president, which I had wished for, and she were being caught up in an impeachment effort, as she would have been, or efforts to reopen the criminal case against her based on her emails? What would I be saying? And I want to make sure I say the exact same thing with Donald Trump as president that I would be saying if Hillary Clinton were president.
So if we look at the shoe on the other foot, can you help people understand what it's going to mean a couple of years from now if there's a Democrat in the White House and we've weaponized and expanded this approach?
Well, I've already commented on that. I did yesterday. And when now the Republicans are going after Biden. And I think they're beginning to set the stage. If Biden were to be elected president, they'd be moving to impeach him, and I'd be on Biden's side. I was on a show last night where they try to push me to say that Biden had committed crimes. And I say, no, I don't want to weaponize the criminal justice system. Today, it could be used against a Republican. Tomorrow, it'll be used against a Democrat.
Right. But in this case, Alan, the thing that I am struck with, and I'm not sure that I completely agree with you that you need a crime. I think high relates to the status of the person as an office holder, and high crime is a misdemeanor as a phrase known in English parliamentary proceedings since the mid-14th century means an abuse of the powers of that person's office. But irrespective of whether you're right or I'm right, and I'm probably guessing you're more right than me.
No, I don't think there's a perfect answer. I think we each have a right to express our opinion on that interpretation.
Right,
this is not the Bible. And, even the Bible is a great story in the Talmud. Rabbis are arguing about the meaning of a phrase in the Bible, and God comes down and tells the rabbis which way to vote. And the rabbis turn to him and say, wait a minute, God, you gave us the Torah, you gave us the Bible, leave us alone. This is our job to interpret it. Yeah. So the two of us have the job of interpreting it, and we probably won't agree, and that's a good thing.
Well, but the point I guess I was going to raise is, and I know you're at a little bit of a disadvantage having not been busy all morning and not having read the complaint that the whistleblower filed. But the gravamen of the complaint is the president essentially engaged in either campaign finance violations by soliciting a thing of value, that is opposition research in the form of an investigation, or he engaged in some form of Hobbs Act-like extortion, corruption. If you want your military aid, you will play ball with me, my private attorney, Rudy Giuliani, and the people that he's sending over to Europe.
And the attorney general.
And the attorney,
the attorney general as well.
Two of them.
Right.
The two of them.
Yeah.
And
right.
so as I look at that, and then they locked down the transcript. They took it out. Exactly. But so you have this point of an effort to obtain information that's personally beneficial to you and not in the public interest, and then locking down the communications about that request. If those facts come to pass, how do you view that in terms of high crimes and misdemeanor analysis?
No, I don't think it constitutes a high crime and misdemeanor or any a crime at all. I do think it's bad conduct and shouldn't be accepted and shouldn't be made the norm. But presidents engage in foreign policy decisions all the time to help their own electability. Presidents have even been known to go to war to help them be elected or to refuse to go to war. That's why presidents have press secretaries. That's why members of Congress have press secretaries. One of the first questions that any elected official asks is, how is this going to work in the polls? It's going to help me. It's going to hurt me. And so, the idea of allowing prosecutors or Congress to probe into the motives of a president is dangerous, because I worry about the limiting principle. I worry about where it could stop. I don't see in the transcript, at least, the quid pro quo. One can argue that it was implicit. The president ordered the withholding of military aid and then said, I want you to do me a favor. If that were an ordinary person, I could see possibly an investigation into a Hobbs Act violation. By the way, I don't think that any campaign contribution can take the form of negative research. I think using any information you get from any source is probably protected by the First Amendment. So I don't buy the first analysis you made that this could be a violation of the election laws. Hobbs Act is a little bit more complicated because if it was a quid pro quo, and Nancy Pelosi has said she didn't think it was a quid pro quo, she may change her view on that when she sees the complaint. But you'd have to really have a fairly clear exchange, which is why I was so upset that we don't have a real transcript. I would think we should have a real transcript, a word-for-word transcript instead of a reconstruction. And, I can understand the White House standing on principle and saying our conversations between presidents and presidents should never be made public or available to Congress, but they didn't take that position. They said, here, we're giving it to you. I wish they had given him a whole transcript and we could have a slightly more sophisticated discussion about whether it crossed the line into a Hobbs Act violation.
Can you explain for our audience Hobbs Act violations?
Well, it's one of those very, very broad general statutes. Maybe my colleague here could do a better job. You were a former prosecutor. You probably prosecuted Hobbs Act violations. So why don't you give us your view, and then I'll tell you why, as a civil libertarian, I think that may be a little bit too expansive.
And Michael, just, if, in your own defense, this sounds a lot like a setup to me, but go at it.
So in broad terms, one cannot use the powers of their office to solicit something of value for themselves. The easiest case is Blagojevich. It's not so easy to say his name, but the former governor of Illinois, who said, if you pay me money, I will appoint you to the vacant Obama seat. That's sort of quintessentially the abuse of the powers of your office. He has the power to appoint. He does not have the power to receive a kickback or a bribe in exchange for that appointment. So the allegation here is similar, not as stark as that, but it is, if you play ball with me, that is to give me information about my political opponent, I will release the aid that Congress authorized for you.
Although today we've seen the quid and the quo have changed a little bit, because at first it was the military relief Congress had promised. But as the day progresses, as the time progresses, we're hearing about the exchange, the promise of a meeting with between the two presidents.
Oh, I don't think a meeting would do it as a quid pro quo. I don't think Congress can or prosecutors can probe into what goes into the decision to have a meeting or not have a meeting. Look, these are complicated and close questions. Article 2 of the Constitution was intended to give the president broad authority. I happen to know something that maybe some of you do or don't know. I'm very familiar with the situation in the Ukraine. I represented the former president of the Ukraine, a man named Kuchma, and I was his lawyer. I went to Kiev. I argued the case along with his co-counsel, wrote briefs, and the corruption in the Ukraine is legendary. Everybody knows. I had to actually leave the Ukraine because one of my co-counsel ended up mysteriously dying at the age of 50-something of a, quote, heart attack. So the United States policy has for years been to try to do something about Ukrainian corruption. And the conversation, of course, the president understood that and talked in general about the issue of corruption in the Ukraine, but then focused it in on this issue of corruption, which had been in the newspapers, namely the firing of a prosecutor who may have been investigating. I don't know the truth of that, and I think it's important to find out the truth of that. But any way you look at it, it's going to be a mixed picture. It's not going to just be the kind of quid pro quo that you talked about in the Bogdanovich case.
Right. But it does raise, it seems to me, as and I agree with you about the weaponization of the criminal law. And I believe that too many disputes are now being asked to be settled by federal prosecutors, which is really a bad use of their resources and time, and is a bad precedent for our criminal justice system.
Interestingly enough, let me interrupt. I've just violated that rule myself. I wrote a piece for the Wall Street Journal asking the FBI to investigate me criminally, because, as you know, I've been falsely accused of having sex with one of Jeffrey Epstein's young women. I never met her, never heard of her, had no contact with her. But today, in the age of Me Too, there's no way of disproving a false allegation, even though I have overwhelming evidence of my innocence and she has no evidence that she ever met me. So in kind of as a last resort, I've asked the FBI to investigate me, investigate her, and indict one of us for perjury. And there's going to be a civil trial, and I've invited the FBI to come and sit in on the trial and determine which of us is committing perjury, because I think it's intolerable to have a situation where somebody is committing perjury by definition in front of a federal judge, a federal jury, and a federal courthouse. So I am now violating my own principles and asking for the use of the criminal justice system to vindicate me against a false civil allegation.
And Professor, but that comes out of the frustration, as I understand it from past speeches, where you have tried to share this with media and found reporter interest wanting.
Unbelievable. I have no interest. We have smoking gun emails that prove this woman never heard of me. She had to be told who I was years after she claimed she had sex with me, and in which the smoking gun emails show that she was told to put me in her book to help her sell books, and then she puts me in the book of somebody she did not have sex with. I couldn't get the media to run a story on those smoking gun emails. The one of the newspapers wanted to do it, and then the editor told them to stop. We don't want to have any narrative that's inconsistent with Me Too. So it's been very hard. I also brought the case to federal prosecutors and state prosecutors, and so right now we're in civil litigation. But sometimes there is the appropriateness of trying to use the criminal justice system to vindicate oneself. But we're off subject now, so I just wanted to get that in because you mentioned the weaponization of the criminal justice system. I'm now weaponizing it myself in what I think is a just cause.
Fair enough. One thing, just again, and it's the lawyer in me that this topic brings rise to, is that you have been very disparaging of the need for the special counsel, the independent counsel. I was an independent counsel. I investigated George Herbert Walker Bush, and I know you're not disparaging me personally.
No, of course not. Or you're, I thought that was one of the best investigations You worked with Lawrence Walsh, didn't you?
No, with Joe DeGenova and
Joe
I
DeGenova.
did it. Exactly.
Yeah,
But
yeah.
the point is that you've argued for the division of the role of the Attorney General between the Attorney General and a public prosecutor's office,
Right.
which is a very interesting idea that may be interest to the audience to have you sort of flesh that out a bit.
Okay, we're the only Western democracy in which the office of Attorney General, which is a political office, it's a cabinet member, is merged with the office of the chief prosecutor. In England, there is the Minister of Justice, political official supposed to help the prime minister and the cabinet. And then there's the director of public prosecution. In Israel is the Minister of Justice, who is the political aide to the prime minister. And then there is the Attorney General, who is the chief prosecutor. In our country, we merge the two roles and we create an inherent conflict of interest. When the Attorney General is sitting in the cabinet room, he is an advisor to the president and a loyal person. Bobby Kennedy, the brother of the president, Ronald Reagan appointed his personal lawyer, Smith, to be the Attorney General of the United States. And I think it creates an inherent conflict of interest when you're supposed to be completely objective as the chief law enforcement, the chief prosecutor, and you're supposed to be completely subjective and loyal to your president when you're the Minister of Justice, the cabinet member. So I think that's why we have special counsel. And I would like to see if it's at all possible within the Constitution to split those two roles, or if not, to have a permanent office like the Inspector General's office, which is highly respected, a permanent office of non-political people whose job it is to investigate and prosecute public officials. But it's a permanent office. You don't just appoint somebody and put a target on the back of certain people and say, investigate those people. So that would be my preferred approach. I wrote that a long, long time ago. I wrote that when Bill Clinton was being impeached.
Yeah. But and I would say in response to that is there is within the Justice Department the Office of Public Integrity. That is what it is there to do. The need for an independent counsel or special counsel now under the current regulations arises when the Office of Special Counsel, the Office of the Public Integrity section rather, determines that they cannot investigate this without themselves having a conflict or an appearance of conflict. So I think we're sort of there, but it relies on the independent counsel to be there.
The problem is that even that office, which is a great office, ultimately the boss is the Attorney General, whose loyalty is to the President of the United States. And unless you made that division within the Justice Department autonomous and not under the control of the Attorney General, there would always be the potential for a conflict of interest.
Fair enough.
Or the appearance of a conflict of interest at the very least.
And to the extent that you can, how do you rate Bill Barr now in terms of independence, in terms of recusal, in terms of issues that are coming out regarding this latest matter?
It's a very interesting question. When Bill Barr was first nominated, I was an enthusiastic supporter. I knew him by reputation. I knew his work that he had done previously as Attorney General. I thought he was exactly the right person for the job. He's a man of great integrity. I don't think there's a single person in his family, starting from the 3-year-olds, who aren't prosecutors. I mean, everybody in his family is a prosecutor, and he lives by the ethics of prosecutors. On the other hand, I think he made a number of serious early mistakes. I think trying to characterize the Mueller report before it was released was probably not a wise thing to do. And I think he has lost in the mind of at least the New York Times and some others the credibility I think he deserved and I think he had. So I like Barr. I think he's a very good person, but I think he made some mistakes. I also think that he did the right thing when he wrote that memo that some people said was a job application. It was not a job application. He didn't need this job. He didn't want this job. But I think the memo was right on. I think it was right on because he obviously accepted my views on what I think obstruction of justice is in the context of Article 2. So I thought that was a good memorandum, but I didn't think he should have done what he did in introducing the Mueller report. But apparently Mueller went along with it. So I don't think that the blame goes entirely to Barr.
Can we talk about Mueller for a minute? And I worked for Barr, and I like Barr as well, and I think he's a person of integrity. His views about the expansive powers of the executive branch are not ones that I share, and I don't share with you the unitary theory of the executive branch. But that aside, you've written, and I have the book, The Case Against Impeaching Trump, a great book, as is Trumped Up, which I have here too, 2 books worth every lawyer's read. You write that the obstruction of justice allegations that Mueller found do not rise to the level of an impeachable offense. And I buy that argument in respect of the president's use of the pardon power or his ability to hire and fire any executive branch official. I think all those things, your argument makes sense. What I don't understand is your analysis, and maybe you could just spell it out for us. It is alleged by Mueller that Trump gave an order to White House counsel to create a false record of his attempts to fire Mueller, and repeatedly did so. How is that not worthy of consideration for an obstruction of justice-based high crime and misdemeanor by the chief executive officer?
It's a very, very good question. Look, I agree with you that a president can't be charged with obstruction for pardoning somebody. Otherwise, George H.W. Bush would have been charged with obstruction for pardoning Caspar Weinberger and the 5 people on the eve of their trial. Nor could he be fired for exercising his constitutional authority to fire somebody or pardon somebody. We agree on that. And I agree with you that the other is a close question. I think it's very fact specific. You'd have to really find out whether what he did was within his lawful authority. Remember that presidents are entitled to withhold information and even sometimes to deceive the public, to deceive foreign people. Might not be the nicest thing to do, but it's done all the time, and it's really part of a president's authority.
Generally speaking, though, Alan, in the realm of national security.
That's right. And I was just going to get to there. But generally, it's not done to deceive prosecutors or to deceive law enforcement officials. And I think if you saw the right factual situation, I mean, the reason I distinguish 3 cases when I write about this. Nixon, who clearly committed impeachable offenses. He destroyed evidence. He paid hush money to witnesses who were supposed to testify in front of law enforcement officials, and he told his subordinates to lie to the FBI. Those are all impeachable offenses and all crimes, all obstruction of justice. I didn't agree with the second, I think, of the bill of obstruction, which just talked about corruption in office. But the others, I agree with that. And I distinguish that from George H.W. Bush, who clearly, if he were not the president, would have obstructed justice. We know why he pardoned Caspar Weinberger. And the special counsel, the special prosecutor, Lawrence Walsh, told us that he did it in order to end the investigation and that he succeeded in ending the investigation. That is a classic obstruction of justice, but it was within the president's power to do it. The president's not above the law. That is the law. Just like a congressman can't be sued for committing a crime that the rest of us could be sued for if he does it on the floor of the House of Representatives or the Senate, with certain exceptions. That doesn't make senators and congressmen above the law, or the president or a judge above the law. That is the law. And so I think your question is a brilliant one. And I would be happy to sit down with you and look at the actual facts and see whether or not we agree that it rises to the level of an obstruction of justice. It is certainly plausible that a president could obstruct justice if he tried to deceive law enforcement officials about why he did something or whether he did something.
Which is why I think, and I'd love to have that conversation with you. I'll take you out to dinner. One of the things,
which we will put on the show as well.
Okay, that's great. We get it catered. One of the things, therefore, that I think the Judiciary Committee is so upset about is the president's refusal to allow McGahn to testify, because that is their sense of how they would flesh out these issues that you and I think are worthy of fleshing out to determine whether or not there was an effort to deceive prosecutors and thereby violate the law.
And that raises the fundamental and very confusing issue of the role of White House counsel. I actually taught a seminar at Harvard one year about the different roles of counsel around the president. We know what the role of his private lawyers are, the ones he pays out of his own pocket. There's also lawyers paid by the government to represent the president in a criminal case. And then there's the White House counsel's office, which is counsel to the White House, not the particular incumbent. And then there's the Attorney General of the United States. And for many, many years, those roles were not clearly delineated, certainly not when President Kennedy was the president, and probably not when President Reagan was the president. I think in recent years, we've seen an effort really to try very hard to delineate those roles. And because we have to understand who has what right to count, who has right to confidentiality, who has whether or not a president can invoke lawyer-client privilege as opposed to executive privilege. And probably the answer is fairly clear that he can't invoke lawyer-client privilege in relation to White House counsel, but he can invoke executive privilege. And we'll probably see those tested.
Yeah, do you really, in terms of the fact that he's already released the summary, now released the whistleblower report, how much argument does he still have left of executive privilege since he can't apply it selectively?
Well, no, it's interesting. The big case on that issue is one that has my name in it. I was not the lawyer. A young lawyer named Mike Mukasey was my lawyer, but I was the client. And the issue was whether I had waived my privilege in the Klaus von Bülow case by writing my book, Reversal of Fortune, where I disclosed a considerable number of conversations between myself and Klaus von Bülow with his permission. And we won the case. And the Second Circuit ruled that no, you don't necessarily waive your privilege if you present certain issues to the public and not other issues. That's analogous, is not exactly on point, but analogous to executive privilege as well. The courts are fairly tough on finding a waiver. It has to be a knowing waiver, particularly if it's a right of a constitutional dimension. So I think there's probably a lot left of privileges that this president can continue to raise.
Right. And in the context of the testimony to the special counsel, that is indeed what the legal strategy was, which was to say that Mueller was an executive branch appointee, McGahn was an executive branch appointee. Conversations within the executive branch did not waive privilege outside of the executive branch. And that I think is something that they're correct about.
Well, but so let me put the question back to you. What about if there had been an interview between the president and Mueller? Even though Mueller's a member of the executive branch, he was serving as a prosecutor. Don't you think that would not be privilege? Do you think it would be privilege?
I think they would waive privilege. They'd have to waive privilege. I think in the same way that Clinton had to waive privilege as a condition precedent to the interview.
Yeah, and also grand jury, but different privileges then come into being. You know, Clinton was very strange because his grand jury testimony was public.
Yeah.
But, when it comes to the president, the rules tend to be somewhat different. Even the impeachment provision of the Constitution provides that only when the president's impeached does the Chief Justice preside. I wrote very controversially in my book that tells us something, that the Chief Justice isn't there only for the formality of his robe, that if I had been the lawyer for President Johnson, Andrew Johnson, my first motion would have been a motion to the Chief Justice to dismiss the indictment on ground that it didn't charge an impeachable offense, violation of the Tenure of Office Act. And would the Chief Justice have to then rule on essentially a motion to dismiss? These are issues that nobody knows the answer to. They're interesting speculation, but the framers never thought of these issues. Why did they appoint the Chief Justice? Was it only ceremonial? Or does the Chief Justice play a judicial role in the trial of a president? He certainly rules on evidence, but can he be overruled by the Senate? If he says something is inadmissible because it's hearsay, can the Senate say, we don't believe in hearsay, let's hear the testimony? We don't know the answer to those questions.
Right.
Professor, we're running out of time, so we'd like to give you the closing comments and thoughts on the weeks ahead.
Well, what an interesting time we live in. I do think that we should be looking to the future and making sure that we don't establish precedents now that will come back to bite us in years to come. This is a very controversial president, and it's when controversial people are being investigated that bad decisions get made. Holmes said, hard cases make bad law. I say difficult people, controversial people often make bad law too. Let's not make any bad law.
Thank you so much for joining us, Professor Dershowitz. And with Michael Zeldin, I'm Richard Levick. This is Real Washington. Thank you so much.
Thank you.
Join the conversation and follow @Levick on Twitter. Don't forget to subscribe to Real Washington on your favorite podcast app and leave a 5-star review. Levick, fixing the impossible.